So I'm sure by now most of you have heard that Remington settled with the Sandy Hook families for $73 million. The attorney for the families gave a statement, and I'm going to deconstruct it because there's a lot of nonsense in this.
Today, we're here, believe it or not, after that, to report a settlement in this case. I'll be honest, I'm not sure I always, I had some cold feet going into the case.
This fool didn't have cold feet. He wants you to think these families burst into his office begging him to help them sue Remington. The truth is, he was at the right place at the right time and saw an opportunity and jumped in head first. Here he is a year ago on a podcast talking about how he got involved with the case.
How is it that you got involved in the case and that you and your father decided to take on the gun industry?
I was getting a ride to the airport from a guy who was a friend of Carlos Soto, who was the first grade classroom teacher's father, Vicky Soto. And so this was about within a week of the event. And I said, boy, I would do anything to help these people. Just tell him to call me. I'm sure his family's been turned upside down. Anything I can do or our firm can do, we will help.
What he did was play the legal friend zone. He acted like all he wanted to do was help in order to gain their trust and make them think that suing Remington was their idea, but it was his idea all along. No matter how the case ended, he wins. If it went to trial and they lost, he still got the publicity of being the attorney for the victims of one of the most famous mass shootings in our history. If he won at trial, he gets that plus a ton of money. Remember, he's a plaintiff's attorney. He takes the case for free, and if they win, he takes a lion's share of the money as compensation. If they settle, as is the case here, again, he gets the publicity, thus bringing more clients and the money. He wasn't doing them a favor, he was doing himself a favor.
PLCAA is a barrier, but PLCAA is not bulletproof. The immunity protecting the gun industry is not bulletproof.
PLCAA is an acronym that stands for Protection of Lawful Commerce and Arms Act. Congress passed this law in 2005 because the gun control lobby was abusing the court system as a way to try to bankrupt gun companies with frivolous lawsuits. They would bring lawsuits they knew they couldn't win, but were extremely costly for gun companies to fight in an attempt to destroy them financially. And it almost worked until Congress passed PLCAA. The anti-gun lobby and Joe Biden will tell you that PLCAA gives gun manufacturers this blanket immunity. This is a lie. What it does is prevent people from bringing stupid lawsuits. If a gun is defective and it hurts or kills someone, you can sue the gun manufacturer for that. What you can't do is sue a gun manufacturer because a criminal used its gun in a crime. That is exactly what PLCAA was designed to stop. In this case, they initially tried to sue Remington because the shooter used a Remington rifle. The lower court said, nope, can't do that because of PLCAA. However, they found a way around PLCAA by using Connecticut state laws about ads and trade practices, claiming that Remington's advertising for AR-15s was irresponsibly geared directly at young teens and as a result should be held at least partially responsible. And I quote, "After the Cerberus private equity firm bought Remington in 2007, it launched aggressive campaigns that pushed sales of AR-15s through product placement in first-person shooter video games and by touting the AR-15 as an effective killing machine." The Connecticut Supreme Court ruled that their argument was an exception to PLCAA. Remington tried to appeal to the Supreme Court of the United States, but they denied hearing that case, so the case was allowed to go forward. Long story short, they found yet another creative way to use our court system to try to financially destroy the gun industry. Keep in mind, this didn't mean their argument would win at trial. It just meant that they were allowed to try it, but that's the problem. Trials are incredibly expensive for defendants because they have to pay attorneys on the front end, where these plaintiffs aren't paying their attorneys anything until they win or settle the case. So they can drag this as long as they want. And keep in mind, Remington has already gone bankrupt twice.
We hope the gun industry takes this under advisement. We hope they realize that they have skin into the game instead of blaming literally everybody else, school systems for not having security to defend against their weapons, mentally disabled people like Dylan Hockley.
I told you, this isn't about saving lives, it's about making a shit ton of money while destroying the gun industry. People have this idea that the gun industry makes a ton of money. They don't, especially compared to other sectors. Open source defense provides a perfect example of how small the gun industry actually is. Ruger is the biggest publicly traded gun company in the world, and their market cap is $1.3 billion. For comparison, Google made $18.5 billion in profit last quarter, i.e. Google's weekly profits exceed the entire value of Ruger. Gun makers are small companies in a low margin business. It doesn't take much to bankrupt them. The anti-gun lobby knows this. They paint the picture of how big and powerful the gun industry is so that you don't feel sorry for them. But in reality, it doesn't take much to bring a gun company to its knees. With this so-called workaround argument to get around PLCAA, now the anti-gun lobby can bring case after case after case after case. They don't even have to win any of them. Like I said, this guy is a plaintiff's attorney, i.e. he does the case for free, and if you win, he gets a large percentage. Whereas Remington has to actually pay for their attorneys by the hour. This case has been going on for 9 years. The amount of money Remington has likely spent on attorneys is probably insane.
Remington, during the pendency of this litigation, went essentially bankrupt not once, but twice. That's what happened after Cerberus got involved. A 200-year company in pretty short order, 2 bankruptcies. And we had nothing to do with that. Which also tells you that maybe all this effort maybe there's a downside, maybe it doesn't make sense. They did it to themselves. And because they were bankrupt, we were limited in the amount of damages that could be recovered.
A lot of people are swearing that they will never buy a Remington product ever again because of this settlement, which is literally doing exactly what the anti-gun lobby wants, destroying gun companies. But as the NSSF statement about the settlement makes very clear, the decision to settle the Soto v. Bushmaster case was not made by members of the firearms industry. The settlement was reached between the plaintiffs and the various insurance carriers that held policies with Remington Outdoor Company, ROC, which effectively no longer exists. As part of bankruptcy court proceedings, the assets of ROC were sold at auction in September of 2020. Remington Outdoor Company, which owned the Bushmaster brand, effectively ceased to exist as a going concern. The lawsuit, however, continued against the estate of the Remington Outdoor Company, essentially ROC's insurers and their insurance policies in effect at the time. Finally, this statement orchestrated by insurance companies has no impact on the strength and efficacy of the Protection of Lawful Commerce in Arms Act, which remains the law of the land. PLCAA will continue to block baseless lawsuits that attempt to blame lawful industry companies for the criminal acts of third parties. This attorney in the anti-gun lobby wants you to think they defeated the gun company. Not really. They got 4 insurance companies to agree to pay them money because they could give 2 shits about protecting the Second Amendment and knew it would be considerably more expensive to go to trial. Remember, this case never actually went to trial. There was no decision made on the facts of the case. Even the Connecticut Supreme Court, who in a 4-3 decision ruled that the case can go to trial, said this. The plaintiffs alleged that the defendant's wrongful advertising magnified the lethality of the Sandy Hook massacre by inspiring Lanza or causing him to select a more efficiently deadly weapon for his attack. Proving such a causal link at trial may prove to be Herculean. Even the court was like, yeah, we'll let you take this case to trial, but good luck winning because your argument is a massive stretch. But you have the grounds to sue under state law, so go to trial and lose if you really want to.
But this case was never about damages in the sense of compensation. It was about damages in the sense of forcing change. If there's any message that you get after learning about all this is, it's money that gets their attention. It's money that gets any industry's attention, especially this industry that is so not used to parting with it, and especially those who underwrite the industry, like the insurance companies.
The one question no one is asking is if this was about creating change and saving lives and proving that the gun manufacturers are responsible for these types of shootings, why did they accept the settlement? Accepting the settlement meant that the gun company didn't accept any responsibility for what happened. There are only 9 people in this suit on the plaintiff's side. Are these 9 people going to split the settlement with the other families who were affected by this tragic event? If this was about saving lives, the only thing that would matter is getting a verdict in court demonstrating what Remington did was responsible for the deaths of those children at that school. Instead, once the number was high enough, they settled. That's literally what the attorney said. The goal was never to win on the merits of the case. The goal was to make it harder for gun companies to get liability insurance because they'd be too much of a risk, because now they can be sued for just marketing their products and then someone using it in a crime. There are over 8,000 to 12,000 gun homicides a year. If you can sue every gun manufacturer for their gun used in one of those homicides, the companies would be bankrupt in less than a year. And that's what they are counting on while getting filthy rich in the process. He thought he was slick by adding that last line, like the insurance companies saw the evidence and thought that they were gonna lose. The insurance companies weren't worried about the evidence. They wanted the case to be done with. The case has been going on for 9 years and hadn't even gone to trial yet. They were bleeding money on attorney's fees while dealing with a second bankruptcy. If you thought you could win on the merits, you wouldn't have accepted the settlement and went and got your verdict in court while still getting your money. You wanted the money. You didn't care about the verdict or making a change. You wanted the money, and because the bankruptcy caused the amount of money that you could get to be capped at insurance limits, you said, well, we'll just take the money and go and act like we sent a message to the gun companies, when in reality, you settled with the insurance companies. The next time you're having a conversation with someone who is anti-Second Amendment, I want you to ask them one simple question. Do you know what the Second Amendment actually says? Most anti-2A people have no clue what the Second Amendment says. They just parrot what the anti-gun lobby tells them. That's why I came out with the "if you know design. In each of these letters is a famous 2A quote along with the actual wording of the Second Amendment. So the next time you're having a conversation with someone who is anti-2A and doesn't know the actual words of the Second Amendment, now you can point to your shirt that you just got and now they know. Guns aren't political. That's why I need your help getting this message to spread on YouTube by clicking the thumbs up button, leaving a comment to let me know what you think of the video, then subscribing to the channel. But most importantly, click that bell symbol. For products featured in this video, click the links in the description.